Good to be here. I come here every year, as you know, and this is the best time to come. Everybody wants me to come this time of year, but I only come here this time of year because you guys are special. I don't know. Anyway, the point is, why is this a good time to come? Because this is the time of year when the governor just finished signing all the laws. A week ago, the governor finished signing or vetoing the laws, so there's a lot of stuff to know about. So that's my topic today, the new laws. I'll also mention some of the new forms that are coming out too. That's important. There's a lot going on. I know I say that every year, but this year it's really true. There's really a lot going on. Important stuff going on, and there'll be important stuff next year too. So I'm glad we have a good president next year too, because there's just a lot to deal with. I might as well start with there's bad news and good news. Let me start with the bad news. Get the bad news out of the way, right? Bad news in the sense that it's not as perfect as we would like it, but the biggest law I think that was passed in California real estate in the last, I don't know, longest time is this new rent control law, right? You're all aware of this, right? There's a state rent control law coming. Could have been a lot worse, but it is what it is. So let's just talk about that. That's the number one topic everywhere I go. So we've got, they call it a rent cap. It's rent control, as you know. It's statewide rent control. And let's just talk about it. First of all, big picture. We got something in California called the Costa-Hawkins, right? Remember Prop 10 on the ballot last election? We all reaffirmed it. So any city or county or state that passes any type of rent control law is limited by that. So in other words, limited by the fact that it doesn't apply to single-family homes, it doesn't apply to new construction, it doesn't apply to vacancies. But of course, everyone defines that differently, right? Every city that has rent control defines that differently, and the state does, so it gets a little complicated. As far as I know, Bakersfield doesn't have rent control, right? Well, you do now. And it's so complicated because, you know, all the cities that already have rent control, San Francisco, LA, San Diego, they've got to figure out how their current law interacts with this law. At least you guys don't have to figure that out because you didn't have a current law, right? So you just have to deal with this law. So what does this law say? It's called the rent cap and just cause. They're two different things. Anytime you have a rent control law, it's got two parts. First, they put a cap on how much you can increase your rent. But since we have Costa-Hawkins that says that doesn't apply to new tenants, every rent control law also has something called just cause eviction. Because think about it. Just cause eviction means you can only evict a tenant for a reason. If you didn't have that, every landlord could always get around rent control by just kicking out all their tenants. Because then you got new tenants, I can do whatever I want. So every local rent control law and this rent control law has two parts. There's a cap on how much you can charge, but the bigger thing, I think, is the fact that to evict a tenant, you need just cause. Otherwise, rent control would mean nothing. All right, so let's start with the rent cap part. Okay, what does the rent cap say? The rent cap says you cannot increase the rent by more than 5% plus cost of living in any 12-month period. What is cost of living? It's regional. It varies by region. On our website, we got this great handout on the rent cap just cause eviction law. If you pull that up, there's a link right on it. You can link to it and see what the regional cost of living is for this region right here. LA, it's 3.3. So in LA, you can't increase the rent more than 5 plus 3.3 or 8.3%. That's the cap they have. Your cap is going to be different. It's different wherever it is. Every region, which is not necessarily determined by a county, but roughly a county, everywhere you have a cap on how much you can charge. So every landlord says, great, I'll increase my rent right now before this law takes effect. Well, you're too late because it's retroactive back to March 15th. So anyone who increased the rent back to March 15th by more than that amount, you can collect it until January 1st, then you got to go back down to 5 plus cost of living, okay? So that's the first thing to remember, that basic rule. Remember, this doesn't apply to single family or new construction, we'll talk about that. So that's the basic cap, retroactive. Some questions we get asked already are, well, if I increase my rent less than the maximum this year, can I increase it more than the maximum next year? Some cities have local rent control laws that allow that. You can charge less than your cap, no, not this one. So no matter how, I don't care if you haven't raised the rent for 20 years, that doesn't mean you can accumulate all those increases and do it all at once, right? So it's 5 plus cost of living every year. So I think what's going to happen is, I know a lot of landlords who, they don't raise the rent for years, and then one year they try to catch up with a big raise. You won't be able to do that anymore. You have to sort of do a little bit each year because you can't bank your increases. Okay? You with me on that? That's the fundamental rule on the cap. You can't increase the rent more than twice in a 12-month period, and it can't go over that cap. It's retroactive to March 15th. That's the fundamental rent cap stuff. It doesn't apply to single-family homes. How do we define single-family homes? You know, some cities don't include condos in single-family homes. This law does. So condos, townhouses, single-family homes are all exempt. It doesn't matter how many you own. You could own 100 of them. You could own 1,000 of them. You're exempt on every single one unless you own it as a corporation, right? So you can own it as a partnership or a trust. You can even own it as an LLC as long as the LLC is not corporate. But corporate-owned single-family homes are not exempt. Okay? All right. New construction is the most interesting thing. So it doesn't apply to new construction. So you got a 4-plex, 6-plex, even though it's not a single family, you're exempt. Do whatever you want. If it's no more than 15 years old. Okay? All right. So does that mean January 1st, 2004 is the magical date? No, it's a rolling 15 years. So let's say today you have a building that's 14 years and 11 months old. And by the way, how old? I mean the date of the certificate of occupancy. So your building is 14 years, 11 months old. You're exempt, do whatever you want. A month from now, you're no longer exempt. You see what I'm saying? Every city like LA, San Francisco that has a rent control law, they have a hard date. They have like 1979 is the date that determines new construction. This is a rolling 15 years. Every day, new properties are going to be not exempt from the rent control. You see what I'm saying? So what if you have a building right now that's 14 years and 11 months old? Raise everybody's rent real quick, because a month from now you won't be able to. You see what I'm saying? That's the definition of new construction. So we got single-family homes, new construction, and vacant properties, which leads to the next thing. Oh, I forgot about another thing. What about duplexes? If you live in half of the duplex, you're exempt on the other half. So even though it's not a single-family house, it's a duplex, as long as you live in one half, you're exempt on the other half. What if I convert my garage and rent it out? You're exempt. What if I have a house and I built a second unit, a granny flat in the backyard? Listen to this. You're not exempt from rent control, but you're exempt from the just cause. You know what that means? You can kick grandma out. But you can't raise her rent more than 5+. Seriously. So you can keep kicking grandma out, or kick them out all the time. You're exempt from the just cause, but you're not exempt from the cap. That's the only place in this law where the exemptions from the just cause are not the same as the exemptions from the rent cap, and that is detached accessory dwelling units. If it's attached, it's considered a duplex. But guess what? You can even have 2 granny flat, or you converted your garage and you have another unit. You got 2 units. You're exempt from just cause on both of them. You can kick out your tenants anytime you want, raise the rent. But for the one that's detached, you can't raise the rent for the existing tenant more than the cap. Yeah?
Is that only if you occupy?
Yes, very good point. To take advantage of that part, you have to occupy either the main house or the accessory dwelling. You can't, if you rent out both of them, you're just like any other landlord. It's not a single family home. You're restricted to the just cause. Now, getting back to this just cause thing, right now, and the just cause part doesn't take effect till January 1st. Right now, if you have a tenant, even though they're paying the rent on time, they're not violating any rules, you can just kick them out. And you give them a notice and they say, why are you kicking me out? I mean, I pay the rent. And you say, because you annoy me, that's right. I just don't like you. You know what I'm saying? You don't need a reason to evict a tenant. You can just kick them out. Starting January 1st, you can't do that. That's the biggest thing about this law, in my opinion. Single family homes, exempt. New construction, exempt. If they leave for just cause, voluntarily exempt. Otherwise, if you got a tenant who follows the rules, they're your tenant for life. You can never kick them out. Unless you have just cause. Well, what exactly is just cause? Well, some things are obvious. They don't pay the rent. They violate some other covenant and you give them a 3-day notice to cure and they still violate it. They don't let you come into the property. They commit waste on the property. They create a nuisance on the property. They damage the property. They commit a criminal act on the property. They threaten the landlord. That's grounds to evict. That's just cause. And the newest one is this. Listen to this. Starting next year, you got a month-to-month tenant. You can go to your tenant and say, I need you to sign a lease. I don't want you to be month-to-month. Tenant says, no, I don't want to sign a lease. Well, then that's just cause for me to kick you out. See what I'm saying? That's sort of a new category of just cause. Refusal to sign a lease. You can always require a tenant to sign a lease. Okay. So those are reasons to kick someone out for cause, for fault. Is there any other way to get someone out next year? Yes. If you want to move in. If you want to move in, you can always kick the tenant out. What if I want to move my kid in? That's good too. You can move in yourself, spouse, ex-spouse, no, your current spouse, children, grandchildren, parents, grandparents. What if I want to move my brother in? That's not just cause. My cousin, no. Parent, grandparent, child, grandchild, that's always just cause. Or yourself. Or seriously, your spouse, your domestic partner. You're not getting divorced, you're just splitting up. So you put them in the, that's fine, okay. That's perfectly okay. Also, here's a couple more. Substantial remodel. I got a fourplex. I'm saying to all my tenants, I'm sorry guys, I'm gonna do a big remodel, you all gotta leave. And then I do a big remodel, raise the rent to market, I can re-rent it. But get this, if you let the old tenants back in who you just kicked out, the law's a little vague. I think you can't kick up the rent for them. You can only kick it up for new tenants. You see what I'm saying? Another thing is you can get out of the rental business. I'm tired of being a landlord. I don't want to be, everybody got to leave. I'm not a landlord anymore. So you kick out all your tenants. That's grounds to kick them out. Then a week later you say to yourself, I think I'm going to get back in the rental business. Raise the rent, right? That seems too easy, doesn't it? Right now, the law says you can do that. I guarantee between now and the end of the year, they're going to put something in the law that says, if you're just going to get out of the rental business, you got to stay out for a certain amount of time if you really want to raise the rents. Because cities like San Francisco do that. San Francisco rent control says, yeah, you can get out of the rental business, but if you come back into the rental business in the next, I forget if it's either 3 or 5 years, something like that, you got to re-rent to the old tenants at the same rent. The state law doesn't say that right now. So right now, theoretically, under the state law, you could, I don't want to be a landlord anymore, kick everyone out, and 2 months later, come back into the rental business, having made no change to the property, and charge whatever you want. That seems too easy. There'll be something. Just like if you move your kid in. You got a fourplex, you got 4 kids. Kick out all your tenants, move your 4 kids in. A month later, all your 4 kids, I don't like this place, they all leave. Great, I can raise the rent, right? Charge you whatever I want. I mean, that's going to be too easy to do some of these things. I'm just saying from experience that I'm not sure that's going to work out. But that's the fundamental rule, okay? But here's the most interesting thing about the just cause eviction. Tenants only get this protection if they've lived there 12 months. So think about that for a second. Next year, I get a tenant, I put them in month to month. 10 months later, I'm sick of this tenant, I kick them out. I don't need a reason. Even though we're under the new just cause rules, they haven't been there a year, I can kick them out without reason and raise the rent for the new tenant. You know what I think we're going to start seeing? 11-month leases. As a landlord, you could avoid this law forever, as long as you just get your tenants in there less than a year. And before the year is out, you can evict them for no reason at all, get a new tenant, charge them whatever you want. That's sort of a loophole if you think about it. Now, what about your current tenants? So I got tenants right now, my building's under market, I need to raise the rent. Well, I just told you can only raise it 5+ cost of living. But of course, the just cause hasn't started yet, so I can kick out my tenants. How much time do you have to give a tenant to evict them? If they've been there a year, 60 days. What's the date today? October 22nd? right? What's 60 days if we count backwards from January 1st? It's like November 2nd. If any of you want to get rid of your tenants, you got 10 days. You have 11 days to give them a 60-day notice. If you wait beyond that, the 60 days would take you into January. Then if they've already been there 12 months, so you get a bunch of long-time tenants right now. They've all been there more than a year. And you want to avoid this just cause thing. You don't want them to be your, maybe you do want them to be your tenants for life. But if you don't want them to be your tenants for life, you got to give them all a 60-day notice in the next 11 days. Then you could get them out by the end of the year, fresh start next year, and get new tenants, charge them whatever you want. Of course, all the new tenants you get next year, once you get them in there, once they stay 12 months, they get the protection. So theoretically, you keep rolling people out every 11 months, you would never be subject to this law. What if I currently have a tenant on a lease? I'm going to assume it's a 12-month lease. And this lease ends before the end of this year. You can kick them out. How much notice do you have to give a tenant to a victim at the end of a lease? Nothing. Did you know when a lease ends, they have to leave? You can call them up the day before and say, just a reminder, the lease is over tomorrow, leave tomorrow. Seriously, month-to-month tenants you got to give notice to. Tenants at the end of a lease, no notice required. So if any of you have a tenant on a lease, the lease is going to end before the end of the year, get them out. But what if I have a tenant right now and the lease goes into next year? Well, I'm assuming it's a 12-month lease, right? Which means by definition, I can't kick them out to the end of the lease. Next year, at the end of the lease, they will have been there 12 months, right? Because they were on a 12-month lease, so they're my tenant forever. So tenants you currently have on a lease that are going into next year, they're your tenants forever. Unless it's a single-family home or a duplex or accessory dwelling unit or new construction. See how this all works? It's very complicated. It's a big deal in cities like LA and San Francisco. You know why? Because like I said, they both have these definition of new construction is like back in the early 80s or late 70s. So there's a whole bunch of properties right now in San Francisco and LA, everything built between like 1980 and 2004, which aren't going to be under the city rent control law, but they're all going to be under the new state law because they're no longer going to have the new construction exemption. To me, the two most significant things about this law are the definition of new construction is a rolling 15 years. And the second thing is the just cause protection only applies if you've been there 12 months. Those are the two sort of unique things I think that are kind of a big deal about this that are going to make it very complicated. And the complex thing. But it's fundamentally, I think, the rent cap is something we can sort of deal with. Most landlords don't want to raise their rent more than like 9% every year. I mean, even if you're under market right now, after a few years of a 9 or 10% increase, you're probably going to reach market, right? I mean, we don't like it philosophically or conceptually, but you know, that's where it is. I didn't mention one other thing, by the way. Let's say the cost of living goes up above 5%. So let's say next year the cost of living is 5.5%. You're limited to a hard cap of a 10% increase. So it's 5 plus regional cost of living or 10%, whichever is less. Okay? You with me on this? I'll take questions on just this now before I even, if you don't have to wait till the, yeah.
So for just cause, if you want to sell it?
Ah, good question. Selling my property is not just cause. I mean, you think, well, the buyer in the house, can't they get their own tenants? No, they can't. Think of the rent control stays with the property. It doesn't matter who owns it. Selling the property is not just cause, unless they want to move in. Moving in is just cause. Or they want to do a substantial remodel. Or they just want to get out of the business completely. But just because you're selling a rental property to someone else, that does not trigger any just cause to evict the current tenants. Here's another thing I didn't mention. Let's say today, you got a fourplex, you got 4 tenants, you like your tenants. You're very happy with your tenants, but your rent is way under market. Okay, so you say to yourself, here's what I'm going to do. I can kick them out, right? Yeah, I can kick them out within the next 11 days. So I'll kick all my tenants out. And then it's vacant, right? So now I'll increase the rent to market, which you can do. and I'll let my old tenants come back in at the new rate. That's what you can't do. So you could kick out your current tenants and rent to new tenants for whatever you want. You're not under the rule. But if you want to kick your tenants out for just cause and then let the same tenant in, if that tenant was in there at any time during the last 12 months, they're still under the rent cap. So you can't have your cake and eat it too. You can't keep the tenants you like and raise the rent as high as you want. You can do one or the other. You can kick them out, get new tenants, charge them whatever you want, or you keep the tenants you have because you like them, but then you're under the cap for those. Yes?
In the real world, a lot of landlords have properties that are the same, but they're rented at different rates. Can you keep the better paying tenants, kick out the other ones?
At this point, if you do it in the next 11 days, yeah. Yeah, you can do whatever you want. You don't need, I mean, the only limitation I would say is you have fair housing laws. So you can't discriminate on tenants based on their race, religion, country of birth, age, gender, disability, marital status. For example, so let's say I got 10 tenants right now. I'm going to kick out all the ones with kids and leave the ones without kids there. I'm Hispanic, so I'm going to kick out all the non-Hispanic ones and leave the Hispanic ones there. You see what I'm saying? You can't do that. Well, Gov, I thought I could evict people for anyone I want. Yeah, but not if it's obviously violating the fair housing law. So you can't pick among your tenants based on that status. But you could certainly pick among your tenants based on who has the higher credit score or who makes the most money. You're allowed to discriminate based on those objective factors. Yes?
I was just going to say, if you could restate the question.
Oh, I'm sorry. Yeah, I'll restate the question. His question was basically, you got different tenants paying different rates. I mean, can I kick some out and not the others? You can always do that as long as you're not violating the fair housing laws. You can discriminate clearly based on objective factors. You can't discriminate if it's on one of these others. California has 19 protected classes. And guess what? They're going to be 2 more. That's the next thing I'm going to tell you. Yes? Yeah. I mean, oh, I see what you're saying. So you have a current tenant. You can kick them out because you have just cause. You don't need just cause. And then you want to rent to them at a different unit in the same building, charge them whatever you want. You can play musical chairs with the end, move them all around. Remember, you got 11 days to do all this stuff, so get busy. Get busy. Yes?
Would you go back over?
I'm sorry, you all heard a question, right? Can you kick out a tenant in one unit, move them to another unit in the same building or same property and raise the rent? Yes, because it's not the same unit. So yeah, you're okay. Yes?
If you have 2 units on one property, corner lot, they have 2 separate addresses. Are those both single family?
So 2 properties on the same lot. They're not a duplex.
They are on 2 single family dwellings, 1 lot, 2 addresses because it's a corner property.
Yeah. So her question is, you got 2 properties on a lot. They're not attached, right? So it's not a duplex. They're just 2 single family homes on the same lot. That's going to come under the rule like an accessory dwelling unit. If you live in one of them, you can rent out the other one. You're exempt from these rules. If you rent out both of them, you're not exempt.
Then it's like considered an attachment.
It's like a duplex for that case. Remember, the only distinction is you can't raise the rent on the detached one, but you can kick them out, get a new tenant, and raise the rent for them. That's the one real weird tweak here. Yeah?
You said you can't sell it. Can you do a 1031 exchange? Is that the same?
So in other words, you do a 1031 exchange, that's still not going to give the new person the right to avoid this law. That's a 1031 exchange isn't going to be exempt. Yes?
Are you seeing like mass evictions from people you're talking to or big landlords?
Yeah, we're seeing mass evictions, exactly, right now.
What about a downturn, like economic downturn? Is this going to dissuade landlords from decreasing rents because it resets the...
It probably is. I mean, it's a good point. His first question was, are we seeing a lot of mass evictions? Yes. His second question is, what if there's a downturn? I guess this is going to, landlords aren't going to be as likely to reduce rents. Probably. I mean, if they can't get the place rented, who knows? But yeah, I mean, there's a lot of unforeseen consequences for this. And of course, the reason CAR theoretically is always opposed to rent control is because it doesn't work in the long run. It doesn't, it decreases incentives to build rental properties, which makes the shortage even worse, and supply and demand, if there's a shortage, the rents go up. So it doesn't solve the problem, but anyway, yeah.
I just wanted to recap. Single-family dwellings are exempt.
Yes, unless corporate owned.
Okay, and that applies to the rent cap.
Absolutely.
Okay, and then the just cause, that applies to everybody.
Right. No, I mean single-family exempt also. Single-family is exempt from everything.
Okay, so if we've got somebody that's on a month to month and they want to sell their house.
If we're talking about houses,
Yeah, so then.
if you guys just deal with houses, don't worry about any of this stuff. Ignore everything I'm saying. Most of you guys probably don't own multifamily buildings. A lot of you guys are landlords, I'm sure, but probably most of you just rent single-family homes. You can ignore everything I'm saying here. I mean, this is not applying to you on your single-family homes. Yeah?
If you advertise a single-family home with an apartment that's attached down the stairway, because you advertise it as an apartment, are you okay?
Yeah, another good question. I'll repeat her question. She said, you got a single-family house and you have an apartment. Maybe you rent out a room in it or something like that.
We rent a room.
Whether it's got a separate entrance or not. The good news is this. That's exempt if you have one of those, and it's exempt if you have two of those.
Okay.
If you got three, you're not exempt. So you, on your single-family home, can rent out rooms or the basement with a separate entrance. I don't care what you do. As long as you're not renting out more than two, you're completely exempt. But if you are renting out three shared, part of the same building, part of the same, say, three, you're not exempt. So up to, and you have to live there, of course, but if you're renting out two, you're totally exempt.
So I can raise the rent?
Do whatever you want. Kick them out. Yeah, you're exempt from that too. Kick them out, raise the rent, do whatever you want. You're exempt if you renting out space in your own living quarters up to two separate ones. But if you rent out 3 bedrooms, even if you live there, you're not exempt for any of them. Okay? So it's the 2 is the big number there. Yeah. Yes?
When you purchase to renovate a multi-unit, can you kick out the tenants without just cause?
Yeah, his question was, I'm purchasing the house to renovate it. It's a rental property, multi-unit rental property, it's not a single family. If you're doing a substantial renovation, you can kick them all out. Of course, the big question now is, what the heck is a substantial renovation? If I just paint the place, is that a, no, it's probably not. Clearly, it's got to be work that requires a permit. But is that the only test to determine what's substantial? We don't know for sure yet. I mean, it's hard to say. Yeah. Another good thing, I'm glad he mentioned that, reminding me of the things I didn't even say first. If you're kicking a tenant out because of a renovation, or because you're moving a kid in or yourself in, or you're going out of the rental business, if you're doing any of those things, you have to pay them 1 month relocation assistance. So if you're not kicking them out for fault, you're kicking them out just because you're doing substantial remodel, moving yourself in, or family member in, or getting out of the business. Today, of course, before just cause, you kick someone out, it doesn't matter if you have a reason, and you can just kick them out and you don't have to give them anything. This is, I'm talking about next year, when you have to kick them out for just cause. By the way, this is not the only thing in the world that's happening in rent control, so I'll take a couple more questions, but there's more to talk about, right? Yes, but this is the most important one, so that's why I want to take your questions. Any more questions? Yes?
How is this going to affect, a lot of people are renting their homes out or rooms out for vacation rentals.
Right, vacation rentals.
How is that going to affect?
Yeah, they're not exempt because it's a vacation rental. So, yeah, they're restricted on that too. Obviously, this doesn't apply to commercial, right? I didn't have to say that, right? We know this doesn't apply to commercial property. But there's another thing I didn't mention, which segues me into my next topic, and we can come back to this, is it doesn't apply to government-assisted property. So if I have a Section 8 tenant, I'm exempt. I can do whatever I want. Now, which leads to in other words, I got a Section 8 tenant, I can raise the rent, kick them out. I don't need to worry about these things, even if it's not a single family home. But the second law that I'm about to tell you about that just got signed by the governor says Section 8 tenants are now a protected class. So let's put this all together. Point number one. This year I have a tenant who's Section 8. I don't want to be a Section 8 landlord anymore. I could give that tenant a 90-day notice to terminate the Section 8. Then I can kick them out even next year. I don't need just cause. Kick them out for whatever reason I want. I got to give them probably a 60-day notice. So it's going to take me 150 days to get this tenant out. But I can do that. I'm exempt from rent control, and I put a new tenant in there. I'm assuming it's not single family. So I put a new tenant in, I can charge them whatever I want. But then, of course, now, if they stay 12 months, they're protected. But if I keep kicking them out, my former Section 8 property is never under rent control. Okay. But starting next year, right now you could just not be a Section 8 landlord. So right now you could put up a big sign, I don't take Section 8 tenants. You don't have to. Starting next year, you can't do that anymore. Well, does that mean I have to be a Section 8 landlord? No, it means you can't discriminate based on that. So what the heck does that mean? Well, think about this. Right now, you have a vacancy. You have two applicants. One Section 8, one isn't. Perfectly legal to pick the non-Section 8, just because the other one's Section 8. Next year, you have a vacancy. You get two applicants. One is Section 8, one isn't. I'll just take the non-Section 8. Okay, maybe. What if the one who's not Section 8 has a criminal record, just got out of prison for murder, has 4 bankruptcies, 3 evictions, and a credit score of 230?
What, like a Section 8?
The Section 8 tenant, on the other hand, the Section 8 applicant is a better applicant based on all those factors. But you hate the idea of Section 8 so much you're going to take the ex-con 230 credit score. That's when you're going to get in trouble. Because then you're obviously discriminating based on Section 8 status. You see what I'm saying? So it's not that you have to take the Section 8, but if you're using that as your sole criteria why you're not taking them, that's when you're setting yourself up. You see what I'm saying? So it's not like you have to take the Section 8, but in the example I just gave you, more or less you do have to take the Section 8, because otherwise you'd be discriminating. You see what I'm saying? Just like today. Today, I mean, you don't have to take the disabled tenant or the tenant of a different religion than you or a tenant in a different race than you, but if you look at your applicants objectively and you take one who has less objective criteria, the one you didn't take is going to say, well, it must have been because of my race, religion, color of skin, gender, disability, blah, blah, blah. You know what I've told landlords for years to avoid getting in trouble? You write down on a piece of paper what you're looking for. I'm looking for credit score of this, income of this, no unlawful detainers on their record, no foreclosures on their record, no bankruptcies on their. I'm looking for whatever I'm looking for. I write it down. The first applicant I get who meets that criteria, I take them. Then no one can ever accuse me of discrimination. Landlords get in trouble because they screen their applicants, they get 4 or 5 that meet the criteria, then they interview all 4. And they pick the one they like best. Then the other 3 can sue you. Because they're going to say, well, obviously I met her objective criteria. I wonder why she didn't pick me. It must be because of my race, religion, color, skin color, blah, blah. You see what I'm saying? If you don't want to be put in that circumstance, you take the first one. Anyway, we have a new category of protected class. But we have another new category too, but this one you're not going to mind. This one I bet you thought was already protected, and guess what who's protected now who wasn't protected before? Military. Do you know up until now you can refuse to rent to someone in the military? Or you could refuse to rent to a veteran. Why would you want to do that anyway? I know some landlords, they don't want to rent to active duty. You know why? Because they get transferred all the time. And they're allowed to break the lease if they get transferred. Some landlords say, I don't want to deal with that. I don't want to take active military, and nothing against the military, but they break their lease. They always leave. Starting next year, they wouldn't be able to do that. once again, that wouldn't be a grounds not to take someone. So we got two new categories of protected classes, Section 8 and military, active or veteran. Interesting, right? All right. What else is going on? We'll come back to this. Let's stay with rentals just for a second. It's not the only stuff going on. Those are the two big things. Little things. I think you knew this already, but if you give someone a 3-day notice to pay or quit now, those are now business days, not calendar days. That's a new thing. Let's say you're not under rent control. Can you increase the rent as much as you want? Yes. But did you know, starting January 1st, if you increase the rent by more than 10%, you got to give 90-day notice. Normally, to increase the rent, you only got to give 30-day notice, right? But if it's more than 10%, it's now going to be 90-day notice. One more thing. Starting January 1st, you cannot stop a tenant, or if you're in an HOA, you can't stop an owner from putting on their front door, their entry door, religious items. Doesn't matter what religion it is. I mean, as a landlord, you can say no political stuff on your doors, no art on your door, nothing on your front door. You can't put anything on your front door. Today, a landlord could say that. Next year, there's an exception for religious items, as long as they're not obscene, as long as they don't violate some other law, and as long as they're no bigger than 1 foot by 3 foot. You have an absolute right to put religious items on your door. Yes, even if the HOA restricts it. So this law that I just applied applies to landlords and HOAs. Absolutely. HOAs and landlords this applies to. Okay? One more thing that's really interesting that I'm sure is not going to, it may happen to you, but listen to this one. You're going to like this one. Or you're going to be interested in this one. If you've got a landlord, you've got a tenant, right? They can't add tenants without your permission. You can always say no tenants. Because once they add someone, now they have the rights of a tenant. Have you ever heard the concept of a lodger? Someone who stays at this hotel, if I don't leave after today, they can throw me out. They don't have to evict me. They call the police. Get this lodger off my property. He's not paying. Well, there's this new law, believe it or not, which says with the landlord's permission, tenants can bring in lodgers. As long as everyone understands that anytime the landlord decides that person needs to leave, they can just kick them out immediately. Or anytime the tenant wants this person to leave, they can kick them out immediately. They don't have any rights other than a temporary right to be there. But to qualify for this status, this person has to be, listen to this, quote, a person at risk of homelessness. What this means is you got a tenant, their friend just got laid off, he has no money, has nowhere to go, he's at risk of homelessness. The tenant says to the landlord, can I let this guy live here for a while? With the understanding that they're just a lodger, and if you ever change your mind, you don't need a reason, not discrimination, you just kick them out. And starting January 1st, if the landlord allows it and the tenant's okay with it, I guess there's no form for this yet. I'm sure there'll be some form you got to fill out, but basically you can let the person in temporarily. They have no rights as a tenant, but they're not breaking the lease either. I mean, I'm sure people have always done this informally, right? I mean, all those tenants like let their friends sleep on the couch for a few days. They never tell the landlord. I guess if the landlord found out, the landlord could say, get your friend out of here. I don't think they ever do, but whatever. This is sort of formalizing what used to be sort of an informal thing. Persons at risk of homelessness. Interesting, right? All right, yes?
On that, if you have a tenant and you put in your lease no overnight guests longer than 3 days, is that legal?
Well, that's another good question. The question was, can you put in your lease no overnight guests more than 3 days? The question is, when does a guest become a lodger? And there's no hard and fast rule. So if you put that in your lease, would that be enforceable? Some say, I got a constitutional right to let my friend stay here for a week. Interesting, I have no idea what a court would react to that. Try it out, get sued, tell me what happens, you know? Because that's sort of a gray area. By the way, before we move on to other topics, I forgot the most important thing to tell you about the rent cap law. There's a new form coming out. And this new form applies to everybody who has a tenant. Let's put it this way. The new law says if you have a tenant that's under the rent cap rule, you have to give them a form telling them about their rights. There's another form coming out that says if you have a tenant that's not under this because it's a single family new construction, you have to give them a form telling them why you're exempt. So whether your tenant is exempt or not exempt, either way there's a requirement that you have to give this tenant this notice. And there's a third notice you have to give another group of tenants. So we could have created 3 different forms and had you try to figure out, is that one of the tenant that gets this form? Does that tenant get this form? Rather, we try to make your life simple. So here's what we did. We combined all 3 forms into one form. So all you got to know is, do I have a tenant? Give them this form. Because part of that form is going to be the required part. But there are no exceptions. If anyone in this room has a tenant of any kind, single family, new construction, vacant decontrol, duplex, granny flat, multi-unit building, I don't care. If anyone in this room has a tenant, you must give this form to that tenant by the end of the year. Guess when the form's coming out? Mid-December. You were thinking on leaving the country for the last 2 weeks of December? You're not leaving anymore. Unless you leave someone behind to give this form to your tenants. What if I don't give it to them by January 1st? You're going to get in trouble. So you got to give them the form. What's the form? It's called the RCJC, the Rent Cap Just Cause Amendment, Addendum. Rent RCJC. It's coming out mid-December. Got to give. Now, we're going to incorporate this into all of our lease forms. So once you give it to them once, any new tenants, you're not going to worry about it. Assuming you use CAR forms, it's going to be in our lease forms. So I guess if you kicked out all of your tenants today and didn't rent to anybody new until mid-December, when our new lease comes out too, you wouldn't need this form because you're going to be using the new lease that has the new form. But if any of you are going to have tenants ongoing this year that go into next year, which is probably most of you that have tenants, you must give this form to your tenants. They don't even have to sign it. What tenants? I'm not signing that. You can't make me sign that. I don't want you to sign it. I'm just giving it to you. You have to prove that you gave it to them, right? But once you do that, you're good. Yeah.
How do you prove that?
How do you prove anything? No, seriously. How do you prove in real estate that you gave the other agent the transfer disclosure statement? How do you prove you gave the tenant the contingency removal form? How do you prove that you gave the other realtor the notice to perform? How do you prove it? There's ways to prove it. There's technology. You get them to acknowledge it. That's an issue you have in real estate. When you give something to someone, how do I prove they got it? That's always an issue. It's always been an issue. So it's nothing new there. Okay? All right. Let's talk about some good things. You ready for some good things to make you happy? All right. Enough of the bad stuff. Good stuff. Have you been hearing in the news, reading the papers about independent contractor? Do you know the rules have changed? Do you know a lot of companies in California now that used to be independent contractor have to change to employee? Like Uber, like Lyft, like a lot of trucking companies. There's a whole bunch of people in California now that can no longer be independent contractors. The good news is we got a law passed that specifically exempts you guys. You're the only ones exempt. We don't care about anybody else, so the law just exempts you. And the law basically says if you got a broker and an agent, they can be independent contractor. You can't be forced to be an employee. You can make as much money as you want. You're not restricted. You can go out and do your own business, do your thing. You don't have to be an employee. That's great. You're exempt. We're just like you always were. As long as you get paid on commission and sign an independent contractor agreement and have a license, you're good. So we're all good, right? Well, some of you, we know, hire people to work for you who don't have licenses, but you treat them as independent contractors. I know realtors, they hire assistants who aren't licensed, or they hire transaction coordinators who aren't licensed, but they treat them as independent contractors. They don't pay them a salary, they pay them for the work that they do, right? I'm not so sure you can do that anymore. So all of you that have working for you someone without a real estate license, but you pay them as a 1099, not a W-2, you might have to change them to an employee. I said might. It's not always. But if I were you in that case, I would call me, I would call the hotline, I would call your own lawyer and say, I got this person, she doesn't have a license, this is our arrangement, can I continue with this, or do I need to turn her into a W-2 employee? Because the exemption that I just talked about that protects us only applies to licensees. So if any of you have a licensed assistant or a licensed TC, you're good. What if I share a TC with other offices? You're probably good. You might want to check with us, but you're probably good. But the rules have changed for some people in your businesses, so it's not completely exempt, something you have to think about. Okay? All right. Next topic of good news. Back to the granny flats, the accessory dwelling units. There have been so many laws passed this year, last year, and the year before that make it so much easier now to build a second unit. Number one, if you apply to build a second unit, the city has to give you an answer in 60 days, yes or no. That's new. Number two, if you want to convert existing space, you want to convert your garage into a living space, basically they can't stop you. There's almost no way a city can stop you from converting existing space. What if I want to build a detached second unit? If it's less than 750 square feet, they pretty much can't stop you. I mean, all the restrictions that cities used to be able to put on you, well, you can't do this unless you add a parking space. You can't do this unless you do this. You can't do this until you build this. Most, if not all, of the restrictions that used to be enforceable by cities, like Bakersfield, I have no idea what Bakersfield does, against you, restricting your ability, are no longer enforceable. They've all been superseded by these new state laws. Guess what? It now applies to HOAs. HOAs can't even stop you from building second units, even if the city's okay with it. So what if I'm running into an HOA or a city that's stopping me? Guess what? We hired a lawyer at CAR. Unlike me, he's a mean guy. His sole job right now is to go after cities and make them allow people to build accessory dwelling units. And if they don't comply, he sues them. He's very mean. So the point is, if any of you are having or your clients are having a problem building an accessory dwelling unit, whether it's converting a garage or building a new one. I mentioned how the rent cap applies to that, but just building it in the first place. If you're getting pushback, first check with the hotline to make sure that they're giving you legitimate pushback, because there's some restrictions they can still have. And if they're not, then we're going to put you in touch with our mean lawyer, and he's going to scare them or sue them, and now all of a sudden you can build your second unit. So that's all in all. They can't require that you live in the main one anymore. What if I illegally converted my garage 10 years ago? I didn't go through the process, I just did it illegally. Well, guess what? You might be legal now. Well, can I still get in trouble because when I did it, it was illegal? No, you're grandfathered in. You can go to the city and say, ha ha ha, I did it when it was illegal, it's legal now, there's nothing you can do to me, na 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 na. You see what I'm saying? Now, they still can require you at this point to do certain things. So let's say you want to be legal now, so you go to the city, I converted my garage, what do I need to do? They can't punish you for doing what you did 10 years ago and renting it out illegally the last 10 years, but they can still require that you do there's certain things that can still be required, if you're following what I'm saying. And you might want to check that out before you even tell them. You see what I'm saying? You're following me here. You know what I'm saying. You get the big picture. The big picture is HOAs can't stop you either anymore. Converting existing space, they almost can never stop you. Smaller ones, they almost can never stop you. Old ones are grandfathered in. There are still some restrictions they can get away with. Check with them, call the hotline, we'll help you out. We have a mean lawyer. Okay? All right. More good news. You have a condo, you have a buyer who's trying to buy a condo. The buyer is FHA buyer. They find the condo that they want. It's in a project that's not FHA approved. Spot approvals are back. You can now get spot approval for FHA approval for a condo, even though the project itself is not approved. It used to be you had to go, the project had to be approved, yes or no, black and white. It's not. Spot approvals are back and they're easier to get. That's good news. Here's an interesting one. It's not real estate related specifically, but it covers everything including real estate. And I don't know if this is good news or bad news. I'm going to say it's good news, because I know everyone in this room is a good person. And that is, the rules have gotten stricter regarding harassment in the workplace. All right. And I don't just mean sexual harassment. I mean harassment in general. 3 big things have happened this year to change. Number 1, the definition of sexual harassment in the workplace has expanded. What was okay last year is not okay this year. Number 2, all of you that work for a company that has at least 5 people working there, if you're in a management or ownership or broker position in that company, you have to take a class on this. This is a 2-hour class, and it's not a class teaching you how to improve your harassment techniques. No. It's a class teaching you what not to do. The third thing that has happened to me is the biggest news of all, and that is, as I try to basically say, harassment doesn't just mean sexual harassment anymore. Harassment in the workplace is illegal. There's something called abusive conduct. Have you ever had a boss, whether in real estate or some other business, that was mean? I mean, what's the fun of being a boss if you can't be mean, right? I mean, as long as it's not sexually related, it's fun to yell at your people, right? Tell them how dumb they are. You can't do that anymore. Seriously, you have to be nice to even, I mean, it used to be a boss could say to their employee, "How could you be so dumb, you moron?" That was legal last year. That is not legal this year. Well, what do I say if they're a moron? Come up with a nicer way of telling them they're a moron. Don't use the word moron, in other words. I try to make everything amusing, as you know, but this is actually serious. How does this apply to you? Well, first of all, whether you work for a business that has 5 people or 2 people, you're still covered. Number 2, this applies to independent contractors. Number 3, the workplace for realtors is not just defined as your own office. Your workplace is everywhere you interact with other realtors, even realtors in other offices. You're thinking, I can't even be mean to realtors in other offices anymore? Yes, that's what I mean. And this is not just the boss can't be mean. It means you can't be mean to each other. Anything in the workplace that can be characterized as intimidating, humiliating, or just a reasonable person would say that really affects your ability to do your work. And you guys all run into people in your life in the real estate world that are not nice, right? Sue them. So point number 1, any of you that work for this company that's 5 or more, you need to take this class. But if you're not a boss, in my opinion, my advice to you is take the class anyway, because you're covered under the law. How are you going to know what the law is unless you take the class? You see what I'm saying? I mean, if you're a broker, manager, or supervisor, you have to take the class. By the way, the deadline to take the class was supposed to be January 1st. It got extended a whole nother year. So you have until January 1st, 2021 to take the class. That doesn't mean you have another year to be mean to people. No, it just, that rule is in effect already. It's just the class requirement. By the way, if any of you have any W-2 employees, they have to take the class too. There's a 2-hour class for owner, broker, manager, supervisors, 1-hour class for W-2s. Most of you in this room, you're not a boss and you're not a W-2. You don't have to take the class. But the new rules about workplace conduct do apply to you. So I don't see how you're going to know what the rules are unless you take the class. The class is free, online. Department of Fair Housing and Employment website. Of course, you know why they pushed the deadline for another year? Because the free class isn't up there yet. It'll be up there soon. But CAR has a class on our website you can take today. It's not free. It's like 50 bucks. So it's up to you, but I recommend when you got 2 hours to kill one day, when the new free one comes out, just take the class. It'll open your eyes. Say, wow, I got to be nice to everybody. Sorry. Well, can I still harass people outside of the workplace? Can I harass someone in a bar? Better not be another realtor. That means you got to ask everybody in the bar, are there any realtors here? Before I start harassing you? Odds are there's a realtor in there. I think a good rule to go by now is be nice to everybody all the time, wherever you are. I think the world would be a better place. So let's just do that, and you don't get in trouble. By the way, if you have a current agent and you promote the agent to be a manager or supervisor, within 6 months of being hired, they have to take the 2-hour class. And then you and them have to take it every 2 years. If you hire a new W-2 employee, they have to take the class within 6 months of being hired, and then they've got to take the 1-hour W-2 employee class every 2 years. Yes?
So now that independent contractors will not be considered employees, they don't have to take the rest of the class?
You're right, you never had to. So there are two different things. Yeah, the independent contractors, you're under the law. You're in the workplace. You can't be mean to not just fellow realtors, vendors, appraisers, affiliates, everyone in the business. But you don't have to take the class. My point is, I think it's a good idea to take the class. Yeah. You had a question? Yeah. Uh-huh.
Can we hug, say, love you, you're awesome?
Can you hug someone, tell them how awesome they are, tell them how nice their dress is? Take the class. I mean, real estate is a hugging industry. When I came in today, several of you hugged me. I am not going to sue any of you. You know, I'm good with it. I mean, if it's consented to, but you can never assume it's consented to. You know what I mean? I mean, I hate to say the safe thing is don't hug anybody. In the real estate world, you guys can't go 5 minutes without hugging each other. I get that. Keep hugging each other. Just be a little careful. And by the way, this all applies to your clients. Do I have to tell you not to harass your clients? Do you know that, right? But you know what? Your clients can't harass you either. You ever had one of those clients? And you put up with all this crap because you want to close the deal? You know what you do now? Close the deal, cash the check, and sue them. But I want them to recommend other people to me. I guess you got to wait till you're retired to sue them, right? But then the statute of limitations will be over, so it's up to you. All right. We make light of this. It's a serious subject. I try to make things entertaining. It's a very serious subject. Other things that are going on. The DRE, what's new with the DRE? Do you know right now there's no commissioner? You know what that means? You can do whatever you want. It doesn't mean that. What's new from the DRE is they've started something just recently. They realize they're not doing as many audits as they used to be. Full-fledged audits are typically triggered by a complaint. If they don't get a complaint, they probably won't audit your office. But they've decided and they've started doing these random sort of limited audits, whether you've had a complaint or not. They'll just call you up and say, they call them broker office surveys. They'll just call you up one day and say, we want to come over and meet and do a limited broker survey. What's a good time for you? Can you say there's no time that's a good time for me? No, you got to let them in. What if they knock on the door and say, who's there? DRE. Don't let them in. You're entitled to them making an appointment. But when they make the appointment, you have to let them in. What are they looking for? They're just looking to see if your agents have licenses, if you have a branch office that's properly registered with the DRE, and then they're going to randomly look at 3 files. Can you pick the 3 files? No, they're going to pick the 3 files. I guess if you just have 3 files conveniently on your desk when they come in. You want 3 files? There, I see 3 files right here. What do you think? You know? By the way, how do I want to know what I need to have in this file. I got good news for you. They have a checklist on their website. Checklist for broker compliance. I would pull this out no matter what in general, just to know what in general I'm supposed to have in my files, right? Pull out the Call the hotline, we'll link you to it. It's right on the DRE website. It'll show you what they're looking for. So that's good. Here's, by the way, you know, obviously you don't have to keep paper files anymore at all. But if they show up at the office, you have to have a way to print out the electronic version right there in the office. Here's good news for you. I may have mentioned this last year, but you no longer have to give your clients paper files. Even though you're not required to keep paper files of your deals, up until this year, if your client wanted it, you still had to give them paper copies. Actually, I had to give them whether they wanted them or not. But now, clearly, electronic copies for your clients are also okay. All right? What else is going on? And realtors, by the way, when they come to your office, they're not going to look and see if you have paper licenses for your agents. Remember, you don't have to display and post the paper licenses for your salesperson. They're not required. It's e-license with DRE. That's all they care about. All right? Last thing is, DRE has hired new staff this year for the sole purpose of trying to get better compliance with the law that requires you to put your DRE license on your marketing. You've heard me say this for 2.5 years now, but you know this, right? Your signs, flyers, newspaper ads, magazine ads, TV ads, radio ads, social media, Twitter, Instagram, Facebook. If you are marketing and your name appears, your license number has to appear and your broker's name has to appear also. You need all three. If you have, it's all or nothing. If you're, and I'm talking about social media, yes. Social media, websites, Facebook, Instagram. If you use social media to market, you got to put your name, the broker's name, and your number. You never need your broker's number. Never need the broker's DRE number. The only place you need the broker's DRE number is on paragraph 2 of the purchase contract. Other than that, you don't need it. What if I'm the broker myself? Well, obviously I need my number on my marketing. With the exception of signs. You never need the broker's DRE number on a sign, even if it's the broker's own listing. Even if the broker works by herself, and she's all by herself, and she puts up a listing for her own listing, her own sign doesn't require her number. But her business card, her flyers, and her social media would have to have her number because it's her transaction. Question?
Digging a little bit deeper, on social media, I'll take Instagram for example. There's the main page, which has the DRE numbers, my office name, and all that good stuff. How about every single person?
His very good question is, Instagram, for example, on the main page, you have your name, your DRE number, your broker's name. But what about every single post? I hate to tell you this. The DRE says every post. We are pushing back against the DRE. We're saying that's ridiculous. And their response right now is, you might have a point. But they've put nothing in writing. If you randomly call the DRE and ask whoever answers the phone, do I have to put it on every post? Sometimes they say yes, sometimes they say no. But their official position is still yes, unfortunately. We're trying to get that changed. Yes?
What about if you have two accounts and they're fully one's business and one's personal?
Yeah, your personal stuff, you don't have to do this. As long as you keep your personal separate from your business, but a lot of people mix them together, you know. But yeah, if it's personal stuff, you don't need to worry about it. Yes?
What about if you have a listing from someone else that you see and you share that listing, but it's not your listing, so you want to, if I have another, how do you?
The question is, someone else has a listing and I'm going to share it. Well, first of all, obviously they have to give you permission to market their listing. But, so you're on where you share, you have to have that agent's information. I think your question is, do I also need my information if I'm marketing someone else's listing? I don't think so. Does the DRE put that in black and white? No, I don't think so. What you got to be careful of is you don't want to be accused of misleading the public to think that it's somehow your listing. If you make it very clear that it's not your listing, I don't think you have to do anything. Because you're not marketing yourself, you're just marketing another property that doesn't happen to be yours. Could it be argued that, well, I'm still marketing myself when I do that? Maybe. Has the DRE clarified this 100%? No. Are they ever going to? I hope so. Like I told the other person, do it, see if the DRE complains. When they file a complaint against you, tell us what happens, and then we'll know, right? Yeah.
If it's an MLS listing,
yes.
do you have permission to market it? I mean,
well, it depends on how we market it. It depends on how you market it. In other words, you know what I'm saying? It depends on like putting up a sign or something. I mean, I'm not going to get into, we could talk hours about this. Just the general question of, if you're marketing someone else's property, is that by definition you marketing that triggers this? I don't think so, but conservative advice is still to always have your DRE. If your name appears, put your DRE number. You can't go wrong if you always put your DRE number. You're never going to have a problem. So all these gray areas I'm talking about, they're not gray if you put your number there. Then you have definitely no problem.
Does it apply to live streaming when you're showing a house?
Live streaming when you're showing a house. So you're walking through the house and anyone can pull up what you're doing and they're looking at you. Yeah. You got to hold up a sign with your license. I don't know what you have to do. The DRE hasn't thought of all these things. But the DRE right now is saying no exceptions. So I don't know how you're going to work that. At some point during that live stream, maybe not every second that you're visible, but at some point, clearly, at the beginning or the end, I think you need, for sure you need your DRE number and your broker's name. Remember, special rules for teams. Hello, Keller Williams. Special rules for teams. Team advertising, the team name can be no bigger than the company name. So you always have to say Keller Williams. It's not just Keller Williams, but you got to say Keller Williams, no bigger than the team name. And you still need the real name of at least one team member and the DRE license of that person. It doesn't necessarily have to be the team leader, but one person's name has to always appear and the DRE number for that person has to appear. Yes?
what about polo shirts?
What about polo shirts? Good question. You don't have to. All your hats, your caps, your pens, your whatever you're using, marketing purposes, things like that, promotional items, don't worry about it. I'm not talking about your hats, your shirts, your badges, your pens. Wherever else you put your name, you don't put your DRE number. Promotional items, at least they've made that clear. Okay? Yes? Record while you're showing the house. Well, now you got a question there. Can I record when I'm showing a house and post it on Instagram? Make sure you have the permission of your client, for one thing, right? I mean, they may not want you putting the inside of their house plastered all over the internet. So you work with your clients, have them understand you're going to take pictures, obviously, of the outside of the house. They're going to go all over the world. Do you have a problem with inside of the house? Do you have a problem with that? Your clients might have a problem with that. You got to be careful, right? You got to be careful with that. And obviously, as a buyer's agent, you can't be walking to someone else's house, taking pictures of everything and plastering it all over the world. You don't have, unless you get written permission, right? So be very careful about, privacy is a big thing now, which leads me nicely into the next, I'm sorry, yeah.
What about if you have your name on your open house sign?
Very good question. Open house signs can just say open house. Or open house signs can just have the company name. But if you put your name on the open house sign, now you also have to put your number. So you got three choices with open house signs. Completely generic, broker name only, or everything. Yes?
Return envelopes where you send out flyers. You have your name and your office address and all that.
The return envelope when you mail out flyers. No, the flyer has to have it. You guys are asking a lot of good questions, but enough on this stuff. But I want to talk about other stuff. Let's talk about forms, right? We'll talk about forms for a second. What new forms are coming out in mid-December? Well, I already told you the very important RCJC, rent cap just cause eviction form, that you're going to give to every single tenant in California by the end of the year. So you got that one, RCJC. Second form that's coming out is not a big deal. It's called the Vacant Land Advisory. Do you know when you sell land? Have you ever sold land? You know you're exempt from all the disclosure forms other than the NHD. But when people buy land, they still have questions come up regularly that buyers of land want to know about. So we got this new optional, not mandatory form that's coming out called the Vacant Land Advisory. You know, we already have the probate advisory, the short sale advisory, the REO advisory, the buyer inspection advisory. Did you notice what came out 6 months ago? The wildfire advisory. Very relevant. So if you're selling a house in an area where there was ever a fire, I recommend the wildfire advisory that came out in June. Now, coming out in December, we have another new advisory, not required by law, good form, vacant land advisory. So I said 3 forms are coming out in December. Number 1, the RCJC, very important if you're a landlord. Second, the optional vacant land advisory. Third, privacy. Listen to this carefully. There's a new law coming out in January called the California Consumer Privacy Act. Big deal. What does it have to do with me in real estate? Well, first of all, it depends on if you work for a big company or a not big company. If I work for a big company, it's not your job as an agent, but it's the company's job to implement a privacy policy, which is going to involve you giving all this information to your clients, telling them something like, any data that we collect from you, you have to tell them if you're going to sell the data to anyone, and if they want you to, they can tell you not to sell it, and if they want you to, they can force you to delete their data. Of course, you got to keep files for 3 years, so they can't force you to delete their files for 3 years. But anyway, there's all sorts of new rules that are going to apply to all big companies, not just in real estate, big companies everywhere. So first question is, how do I know if I'm a big company? Well, here's what a big company is. Number 1, do you make half of your income or more by selling data? That's none of you. Second question, does your company that you work for have $25 million in gross revenue? You got to think about that. I don't know who you are, but if your company, if your gross commission, not net, your gross commission income is 25 million or more, you're under this law. The third people that are under this law are companies that collect information from clients 50,000 times a year. You're going to say, that's not me. But you know, if someone goes to your website one time, that counts as 1. So let's say someone loves your website and they go to your website 5 times a day, every day of the year. That's 1,800 for one person. That could add up to 50,000 pretty quickly, right? So once again, for you guys, does your company have gross revenue over 25 million, or do you collect client data in any way, shape, or form 50,000 times a year? Let's say you tell me, Gov, I'm a small operation. There's no way I get 50,000 hits on my website. I don't make $25 million yet, unfortunately. I guess I'm exempt, right? Well, you're exempt from part 1, which is implementing a privacy policy. And by the way, we have for you today on our website a privacy policy which you can just use it. It works. If you use the sample policy we've created, you're good. So you're saying, that's not me, I guess I don't have to worry about this new privacy law, right? Well, no. The second part of this privacy law says if you are doing a deal and working with a client, and as part of that client, your client is dealing with a big company, there's something you got to do. So what if the company on the other side is a big company? Or they're probably putting their information on Zillow, aren't they? That's a big company. So in other words, pretty much every transaction you do, even though you're not a big company, there's going to be a big company involved. Your client is going to be, just by putting the information on the MLS, they're giving information probably to a big company. Aha. So now what do I got to do? What do I do if I'm in that situation? Well, you got to give your client a form. It's just a disclosure form about their rights under the privacy law. That's the third form I'm talking about. But here's the problem. The law doesn't come into effect until 6 months after the regs are finalized. The regs haven't been finalized yet. So when you know the law is not going to take effect until at least April 22nd. But if the regs don't come out by July 1st, the law takes effect on July 1st anyway. So sometime between now and July 1st, this law is going to take effect. We're probably not going to have the form ready until the law takes effect, because we don't know what to put in the form until the regs are finalized. Do you understand what I'm saying? So we sort of have a draft of the form, and if the regs are finalized tomorrow, we may have the form ready by the mid-December forms release. On the other hand, we might not. So here's the bottom line. Mid-December, for sure, you're going to see 2 new forms. Number 1, the rent cap just cause addendum, which you're going to give to every tenant. Number 2, you're going to see the optional vacant land advisory. Then, either on mid-December or sometime going into next year, a 3rd form is coming out. It's going to be the privacy form. It's going to be the form that you're going to have to give to all your clients in every deal that involves a big company. And you know what we're going to say to you? Give it to every client. Do you need to be running around trying to figure out if you're dealing with a big company, or you're just going to give it to everybody? You know how you give the agency form to everybody? This is another form you're going to give to everybody. It's going to be pretty simple. Give them the form. That's not too hard, is it? So just be ready for it. It's all going to happen before you see me again. Usually I come here in the fall. So before that, sometime before then, there's going to be a privacy form that you're going to give to your clients. Yes?
I have a client that I'm putting a house on the market this week, and she has one of these cameras inside her house, and she's got an audio and video.
Everybody who comes onto the property.
And I'm telling her not to, but
she has the right to do that. We have the right to our own inside of our house. We can video. You got to tell people. So she's got to put up a sign. Like you see when you go to 7-Eleven, smile, you're on camera. She's got to put up a sign telling everyone, when you're in my house, you're under surveillance. And guess what? This sounds like a joke, but in all seriousness, she can't put that in the bathroom. Seriously. You cannot put cameras in your own bathroom so that when people come in, you can film them in the bathroom. People have an expectation of privacy in your bathroom, in your house. You don't have to let them in the house in the first place, but if you do, but everywhere else in the house, they're fair game. So she can put up cameras and audio throughout the house. She's got to tell people, though, that when they come there, you can't keep it a secret. So in your case, if she puts up a sign or something on the front door, inside the front door, which, by the way, our listing contract already mandates, then they can do it. She can do it. He can do it. But not in the bathroom. Don't be putting that in the bathroom. Okay. All right.
Come out with the listing agreement, the purchase agreement, like the wire fraud. Is it going to be part of the package?
Yeah, the question is, his question is, this privacy form I mentioned, is it going to be like come out in zip form as part of your package, like the wire fraud advisory and the buyer? I don't know. As you know, zip form has like 200 forms. But there's only a couple that we actually physically attach to your, for example, purchase contract or listing contract. The purchase contract, as you know, you automatically get the wire fraud advisory, the agency disclosure, the dual agency form, and the buyer inspection advisory. It could very well, this might be a 5th form that comes with your, or maybe it'll come with your listing, or maybe it'll be an independent form and you have to figure it out on your own to get it. Anything's possible, I don't know. Okay? The other big news on forms, of course, I think I already said this, is all of our leases and rental agreements and all of our landlord-tenant forms are going to incorporate all of this new rent control stuff. So this RCJC form, you're really not going to need it once you have a tenant under contract, right? But all of your existing tenants, you have to give them all the RCJC. All right, that's the big forms news. Is there anything else to tell you to make you happy? Can I send you away on a happy note? Not really. Okay, no, a couple of things. Do you know appraisals are no longer required on residential sales under $400,000? Did you know that? I mean, you can still get an appraisal if you want one. but the lender's not going to require a full-fledged appraisal. You know what the limit was up until recently? $240,000. So it just jumped from $240 to $400. So that's good. What else is new? Here's something that's new. Effective July 1st, 3 months ago, 4 months ago, whatever, if you put in a new garage door opener in your house, the garage door opener must work without electricity. It's got to be battery backup. In other words, and don't tell me, well, you can open it manually. Isn't that good enough? No. If there's a button on the wall that you press to make the garage door go up and the electricity is out, it's still got to work. This is not retroactive. You don't have to retrofit your existing one, but if you put in a new garage door opener since July 1st, it's got to have that feature. Okay? What else randomly should you know about? Just a couple other things. I can tell you're getting restless, you're tired of this stuff, but I got to tell you all the bad news, right? Yes, it's my job. We've seen a bunch of realtors recently, we haven't seen this for a long time, a bunch of realtors have gotten in big trouble for their agents violating the do not call rules. Nothing has changed, but I think some newer brokers aren't aware of the rules. Remember, if you're going to cold call people, you have to check the do not call list against the number you're calling. If they're on the do not call list, you can't call them. How do I figure out where the do not call list is? How do I figure out this stuff? Of course, on our website, car.org, we have a Q&A on the do not call rules, how to be compliant. You also can't use robocallers, even if they're not on the do not call list. I mean, you can use robocallers, but if they answer the phone, they have to get a live body. Have you ever picked up the phone, you got a recording? Sue them. They shouldn't be doing that. They shouldn't be doing it. Realtors can't do it either. Okay, so don't violate the the laws on that. Is there anything else you should know? I'm trying to end on a happy note. Let me tell you one more unhappy thing. Well, you know what? People always ask me, Gov, what are the latest lawsuits? What are you seeing now that you haven't seen before? You ready for this? Marijuana. You know it's legal now, right? Yay, no, just kidding. But you're going to have clients who grow marijuana legally. There was a recent case where a client was growing marijuana in the house. Legally, 6 plants, over 21. They take down the plants before they sell it, because they have to, right? Did you know that? You can't sell the house with the marijuana in the house. You know why? Because you're getting title insurance. The title industry is federally regulated. Federal law doesn't allow marijuana, hence, at the time of sale, you can't have the marijuana. So what if the buyer's looking at the house and they see the marijuana and the buyer says, great, I'm getting marijuana with the house. And the seller says, yeah, I'll give you the marijuana, no problem. They still can't do it. The seller has to take it out, and they got to do a drug deal outside of the escrow. So your clients have to be drug dealers, but that's illegal. They can't charge for this. They can't make the buyers pay unless they have a license. But they can give the 6 plants to the buyer. But that's not even what I was getting at. The lawsuit was the listing agent knew the seller was growing the marijuana. Most of you guys are probably so innocent you wouldn't even recognize a marijuana plant, right? Me too, I don't know what they look like. But anyway, the seller was very aware that the marijuana was in the house. Seller took it out. Realtor says, I don't need to disclose that. They took it out. Buyer buys the house. Buyer moves in. Guess what? There's marijuana in the carpet. It's in the drapes. It's in the vents. Cost them a lot of money to clean it up. They sued. The realtor says, you should have told me the seller was growing marijuana in the house. The realtor was an extremely honest person. She admitted that she did know. And she had to pay. She lost the lawsuit. She had to pay. What's the moral to you? If you have a listing and you know they're growing marijuana, tell the buyer. Disclose it on the TDS or the Avid or whatever. Second lawsuit we're seeing. Listen to this. Buyer buys the house, goes into the backyard one day to hang out, and the neighbor in the backyard is smoking marijuana. And the marijuana drifts over into their yard. And they're all of a sudden getting high, and they don't want to be getting high. They're suing the seller. What are they saying? You should have told me the neighbor smokes marijuana and the fumes come over into my property. Fortunately, these aren't realtor lawsuits. They're only suing the seller, because how could you know? But we now have to add a new question to the seller property questionnaire. Can you smell your neighbor's marijuana smoke? This is not a joke, unfortunately. This is serious. Let me tell you one more bad thing and then more good, and finish with a good thing, okay? Let me tell you the bad thing that's really going to make you mad. And then I'll tell you a good thing to make you happy. Okay. First of all, I bet you didn't even know this, but did you know that daycare centers and residential care facilities are very protected in California? Here's how protected they are. You have a listing. Next door to the house you have listed is a sober living facility, it's a senior citizen home, or it's just a kid's daycare center. Did you know by law you don't have to disclose that to a buyer, that they're buying a house right next to a daycare center? You don't even have to tell them. In fact, you're not even supposed to tell them if you want to. You're not allowed to disclose it. Is that crazy? That's how protected they are. And that's not even new. What's the definition of a daycare center for that law? 8 kids or less. So big daycare centers, of course you have to disclose it. But if there are 8 kids, now how are you supposed to know how many kids are there? Right? Go next door, knock on the door. How many kids are here? Anyway, the point is, the cutoff was 8. The cutoff has now jumped to 14. So as long as there's no more than 14 kids there, you don't have to disclose as a neighborhood condition to anyone who's coming to the house. What if you want to disclose it? You still can't. So what do you do with a buyer? You like your buyer, you want your buyer to know this. You tell your buyer, you might want to drive around the neighborhood during the day, during the week. Look around, you know? But it's even worse than that. I'm just telling you this to aggravate you. I don't know why I do this. You're a landlord. You own a single family home, perfectly nice house. You put it up for rent in this nice neighborhood. You put in your rental agreement, tenant, you cannot operate a business out of this house. You have the right to say that, and they're not allowed to open a business. They probably need a license anyway. It's probably not zoned for that anyway. But you have the absolute right to tell your tenant they cannot open a business in the rental. Unless they want to open a daycare center. In that case, even if the lease prohibits it, they can open the daycare center. Yes, you can require that they be licensed. Yes, you can require that they pay for very good liability insurance that completely absolves you of any possible claim on any basis whatsoever regarding the daycare center. But you can't stop them from doing it, and that has also jumped from 8 to 14. I knew you'd love this. Yes?
What if you're in a senior community and they're not permanent residents, these children?
Wait.
Say you're running a daycare center and you're a senior citizen in a 55 or older community.
Oh, so you're in an age-restricted place. You're a tenant in an age-restricted place, and now you have these kids. No, you can't do that. Yeah, it's not. You can't go that far.
Grandma's daycare.
Right, you can't go that far. By the way, grandma's daycare is a good idea, but no. Yes. Yeah. Yes. You can raise security deposit. You can also raise the rent to a reasonable level. You can't just, I'm going to triple your rent if you do this. It's got to be reasonable. In other words, you have to reasonably accommodate a daycare center. The reasoning behind this, by the way, is the government is telling you daycare centers are a good thing. And they should be in residential neighborhoods. People shouldn't have to take their kids to a commercial area. People should be able to take their kids to a residential area, but if it weren't for these restrictions, nobody would allow them because no one would live next to them And if it had to be disclosed, they just wouldn't exist in residential neighborhoods because no one could get away with it because no one would buy any house anywhere near. You get what I'm saying. So you got to deal with it. Don't fight it. Remember, I have one more good thing to tell you before you leave. But questions on this? Yeah.
How about an elder care or a disabled care?
Yeah. So I was telling you about daycare for 14 kids. Everything I said also applies to residential care facilities where 6 or fewer people live there. Disabled persons, senior citizens, battered spouses, sober living, recovering addicts. Everything applies to them too, but it's 6 or fewer living there. So we're talking about 6 or fewer living there or 14 kids with daycare. What about adult daycare? This is not covered, so they're not exempt. Adult living up to 6, kids daycare up to 14. Very complicated. Do you think any other state has anything like this? New York does, but that's it. No other state has anything like this. I tell people about this just to get the reaction. I love to get the reaction. I shouldn't do that. I'm going to tell you a good, question.
Would that be considered just cause?
Just cause eviction? Absolutely not. In other words, you can't evict them because they decided to open a daycare center. But wait a second. It's a single family home. I'm not under just cause. Yeah, I can do whatever I want. Uh-oh. But it's a protected class. Remember, there's several things you have to think about. Just cause is great, but you still can't evict protected clauses. Like the Section 8. The Section 8, you're not under the rent control. You can do whatever you want with a Section 8 tenant, but you can't discriminate against a Section 8 tenant. Which leads to a question I didn't even address earlier. Remember what I said, you can get out of the Section 8 business? All you got to do is give 90-day notice. But is getting out of the Section 8 business discriminating against Section 8 tenants? I hope not. And I don't think so. But you see, the problem is all these laws that I'm telling you about were signed last week. And every time new laws get signed, they didn't think of certain things when they wrote the law. And we got to wait until either a regulation or a court case before we know for sure. That's why, unfortunately, I'm a little vague on some of my stuff today because I just have to be. Now, I promised, but I'll hang out as long as you want, but I promised to at least tell you something more good. Remember I told you good things? Independent contractor, accessory dwelling units, harassment, we're all going to be nice to each other, spot approvals for condos. Remember all that good stuff? Privacy form is going to take care of you. Appraisals not required up to $400,000. Then I told you the bad stuff. Section 8, rent cap, just cause. That's not so great. And then I told you about the 14-kid daycare. Not so great. Of course, it's great, I guess, if you want to open a daycare center. It's good for you, right? When I say not so great, I mean in general for property owners. Okay, but what's the more good thing? And I sort of said this last year, but I really want to drive it home. An age-old problem in real estate has been, I'm the listing agent, I deliver stuff to the buyer agent that they're supposed to give to the buyer, and the buyer is supposed to sign it and give it back, right? This happens. All these disclosure forms, by law, the seller signs it, the agent signs it, give it to the buyer. The buyer is by law required to sign the disclosure and send it back. But what if they don't? What if you're dealing with a buyer's agent who's not so good? And they don't follow the rules, and they don't give you their avid, they don't give the TDS back with the buyer's signature, they don't return the lead paint form, they don't return the NHD form, they don't return the SPQ, they don't return all the things they're supposed to return signed by the buyer. That agent is violating the law. That agent could get in trouble with the DRE, that agent could get in trouble with their own client. But here's the good news. It's not your problem anymore. So if you give a disclosure, any of the disclosures signed by the listing agent, signed by the seller, delivered to the buyer's agent, and the buyer's agent acknowledges that they got it, you are done. If it never comes back, you still have a clean file. If the DRE looks at your file, they don't care if they don't see a buyer's signature. They don't care if they don't see the buyer's agent's signature. They don't care if they see the buyer's agent's avid. They want to see that. If you are dealing with they're going to go after the buyer's agent in that scenario. In other words, you don't get punished because the buyer's agent doesn't give you back the stuff they're supposed to give you back by law. That buyer's agent could always get in trouble, but at least you have a clean file. You can close the deal. If you get audited, you're okay. And that 5-day right of rescission. Do you know when you give a disclosure to the buyer, they have 5 days to change their mind? So buyer's agents used to deliberately manipulate that by delaying their disclosures, so when the buyer finally gets it, they're near the close of escrow and the buyer can still walk away from the deal because they still got their 5 days. The biggest change in the law is that the 5 days that the buyers have to change their mind begins when you deliver it to the buyer's agent, signed by you and the seller. Your seller signs it, you sign it, you deliver it to the buyer's agent acknowledges receipt, that's it. Your file is done, everything's good. 5 days later, the buyer's right of rescission is done. If you're dealing with a good buyer's agent, they're going to do the right thing. They're going to get it all signed and they're going to get it back to you. That's what the law requires, that's what the RPA requires. But at least you don't get harmed and your seller doesn't get harmed if they're not so good. So that's what I like. That's my happy news. Now before I let you all go, I'll take more questions, but let me preview next year when you have the best president around, right? Yeah. She's going to have a fun year. And because all these political stuff is just going to happen, there's going to be challenges to Prop 13, there's going to be more rent control issues, there's going to be proposed sales tax on commissions, they're going to try to outlaw dual agency, so we just have to be vigilant and fight. She's going to fight for everything, you know that, but we need everybody's help. So what that means is when you get these emails, you know, red alert, call your assembly person, email them, do it, those work. You'd be amazed at all the bad laws that didn't get passed this year thanks to the realtors. Plus, when she asks you to increase your political contribution from the mandatory 49 to something more, if you can, every cent you contribute helps. Because money talks in politics, like it or not. So it's going to be a tough year. I mean, based on the legislative makeup in Sacramento right now, it's a challenge. The other big news next year is more just local for us is, yes, it's 5 or 6 years since the last time the RPA is going to be changed. So I'm sure you're all going to come to my RPA class next year around this time, aren't you? Because it's not going to be effective till December next year. But starting around this time next year, I'm going to be available. I'll come out to Bakersfield as much as you want. You all should probably take the training. Substance is going to change, but the purchase contract is going to look different. It's going to be better, we hope. But anyway, the point is, it's every 5 or 6 years, there's a major change to the purchase contract. So get that on your radar. You don't have to do a thing until a year from now. It's not even coming out until mid-December next year. Not this year, next year. But we're going to start offering training like next September or August. You'll see me everywhere. And of course, I'll come back here next year around this time to tell you all the new laws that get signed, which is always fun. You're a great group. You ask a lot of good questions. Plus, you're a very well-dressed group. I like that. I don't know. Thank all the men here wearing ties today. I appreciate that. Just for me. Anyway, a couple more questions. Yes? Yeah. I'll take 2 more questions, then we'll go. Yeah. Yes. 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 What I just said applies to TDS. Let's take 1 more question, then if you have more questions, I'll just hang out. Yes. Last question.
HOA, you've been requesting transfer documents for 10 days. Do I have to give another 5 days once I do finally receive them?
Very good question. We've been requesting the HOA docs. We haven't got them yet. Does the buyer still get an extra 5 days when they finally come in? Yes. It's a problem with HOAs. It's always better to order them early, but you're at the mercy of the HOA when they're late like that. Do you want to say something?
I was just going to tell everybody thank you and goodbye whenever it's time.
Then it's time for you to do that, because I'm done. Thank you very much.